everyone, welcome to my channel. Before watching this video, don't forget to like, comment, and subscribe. Now let's start this video. Maritime versus non-maritime law. Because maritime law has developed for the purpose of facilitating maritime commerce, it has a number of differences from non-maritime law, many of which first developed from the ancient sea codes and English development of the codes. For example, maritime law liability standards are often different than those under local laws. Damage under maritime law are often different than those under local laws. Maritime cases can be proved in federal court without regard to diversity of citizenship or amounts in controversy. Maritime cases are generally tried to a judge rather than a jury. Maritime law often treats vessel as legal person in rem. Maritime cases permit ex parte prejudgment attackment of property without any need to show good cause or subject to certain jurisdictional standards. Maritime includes limitation of liability rights for vessel owner. Most maritime cases are not subject to statutory limitation deadlines, unlike cases under state law, but instead are evaluated for timeliness under the equitable doctrine of leases. Oral contracts are always valid under maritime law, but often not valid under state laws. And parties in maritime cases can often take advantage of expedite discovery rules and other means to obtain evidence quickly. Maritime law is a dynamic and evolving branch of law in the United States through both developments in maritime common law and through congressional and federal government administrative action. Congress and the courts continue to grapple with new maritime issues presented by offshore energy exploration, change in transportation technologies and systems, and ever-increasing use of waterways for energy, trade, fishing, and recreation. Yes, maritime law may extend to non-maritime matters if the activities are related to maritime matters. United States Supreme Court cases in 2004 and in 2010 significantly expand the reach of maritime law to cover even the inland portion of multimodal shipments due to the need to allow for a uniform remedy system to cover shipments from point of origin to point of destination. Other combination of congressional action and judicial decision have led to a gradual expansion of maritime jurisdiction. For example, the reach of the Death of the High Seas Act has expanded as court and Congress have confirmed that the Act covers death from offshore aviation accident as well as those on board vessel. In commercial litigation, an expansive reading of maritime laws, remedy of maritime attachment to cover wire transfer passing through intermediate banks in New York, led to a massive volume of maritime cases in New York until the Second Circuit Court of Appeals, encouraged by overwhelmed district court judges, put some limits on the practice. Maritime law has also been extended to civil forfeitures arising under federal criminal laws. Jurisdiction largely falls under federal courts, but because maritime courts cannot extend to non-maritime matters, there is a savings to suitor clause. This allows a party to request the use of common law through state courts, currently with maritime courts, for things like property claims, cargo damage, or even personal injury. These are instances in which it is reasonable for the party to have the right to a jury trial under common law. Admiralty law dictates that the flag of a ship is what determines the law by which it is bound. This means that a United States This means that United States ship in foreign waters is subject to United States maritime law, but a foreign ship in American waters is subject to the laws of its own country. Although maritime law is a unique body of law, it has many links to state laws and other federal law. In those cases where existing maritime law does not address a particular issue, a maritime judge may look to state law to guide the decision. The state court judges trying maritime cases under the In state courts, judges trying maritime cases under the saving to suitors clause, such as those involving boating accident or maritime contracts, must apply maritime law. As a consequence, federal maritime law and state laws are interrelated with developments in one system necessarily affecting the other. In general, federal maritime law supplements and overrides most state and other federal laws. The underlying goal is uniformity of the legal rights and remedies that affect the world of shipping and maritime commerce. One area where the existence of maritime law that overrides state is most relevant is the law of contracts. The application of maritime law can influence anything from the type of damage that are recoverable for a breach of contract to the enforcement of contractual insurance and indemnity obligation. To fall within the scope of maritime law, the relationship between the parties and the nature of the service typically determine whether a contract is governed by maritime or state law. However, even what might appear to be an obvious example of a contract that should be governed by maritime law is not always the case. For example, a contract to build a vessel is generally not a maritime contract, while a contract to repair a vessel is. To determine whether your contract is governed by maritime or state law, courts have identified general factors that apply. In 1870, the United States Supreme Court ruled that the application of maritime law to contracts is determined by the nature and subject matters of the contract and whether the service rendered pertain to maritime service or maritime transaction. This somewhat vague test has been refined over the years. In 2004, the Supreme Court embraced a more conceptual approach and focused instead on whether the principal objective of the contract is maritime commerce. Since then, the United States Fifth Circuit Court of Appeals, which encompasses two Gulf states of Texas, Louisiana, and Mississippi, has applied a two-part analysis which considers whether the contract provides service to facilitate the drilling of the production of oil and gas on navigable waters, and if so, whether the contract provides or whether the parties expect that a vessel will play a substantial role in the completion of the contract. In cases not related to oil and gas exploration and development, court will consider the nature and extent of the involvement of the vessel crew in carrying out the service contemplated by the contract. While there is no clearly defined litmus test to determining whether maritime law applies to a contract, the primary focus is the relationship with and/or impact on maritime commerce and the involvement of a vessel. Okay everyone, that's all this article today. Thank you so much for watching this video. Until the next one, bye bye.